go back up to Michigan. Spend a little time with Judge Mom.
Happened alongside Defendant Caleb Dobson, present this morning for a scheduled sentencing and bond violation matter.
All right, thank you. And sir, your name for the record, please.
Caleb Dobson.
Okay, and thank you for dressing appropriately for court. All right, so originally, this matter was scheduled for sentencing November 12th, and this is on your client's plea to an amended charge of operating while intoxicated first offense. It had been reduced, the two original charges of operating while intoxicated second offense had been dismissed. We originally scheduled this for sentencing November 12th. It was not scheduled, or we did not conduct it because your client was interested in sobriety court in the 17th District Court. It appears as though there was outreach attempted by the 17th District Court sobriety court to no avail to your client. And so then we were set for January 7th. We did not call the case on the record. You were set to be in another court and we were running behind in our docket. It was extremely large that day. And then you indicated you're still working with treatment court for your client. Which treatment court was that?
So, Your Honor, I had initially followed up with the 17th District Court. I was in contact with the clerk from that court. She did advise me, though, regrettably in January, following our last appearance for you, that they were no longer accepting transfers, and so we weren't able to proceed with 17th District Court. However, after speaking with Ms. Shaw from the probation department, we did also begin to make contact with Harper Woods. However, they did not indicate a response. In terms of acceptance at this point, we would need to go through a more formal screening process with them as well. So we did make some efforts. And if Your Honor, if I may expand on the efforts, both in terms of what Mr. Dobson received from 17th District, as well as there were follow-up efforts on his part that are not necessarily noted or reported in the PSI, but I can speak on that as well.
Okay, well, a couple things. So here, counsel, is my question. So you have Harper Woods that you've reached out to on behalf of your client. When did you reach out to Harper Woods?
Just prior to the holiday, I received the response from 17th District Court that they were not accepting transfers on January 12th. From there, I did follow up with both Ms. Shaw as well as make a telephone call to the sobriety court, treatment court in Harper Woods. And I was awaiting response to the information. And then unfortunately with the MLK Day closure this past Monday, that kind of further delayed a more formal response. So that was something that we were looking into. However, with respect to that, we are also to the extent or degree that we are able to, as it relates to the Dearborn Heights matter, we have been in contact with that court as well. And we are prepared to make arrangements through them with respect to help securing a transfer into a.
So tell me about the outreach from the 17th District Court that indicates that your client did not respond. And I will note, here's that sentencing was adjourned on as defendant was interested in sobriety court. This was from the November 12th date. Then it says defendant did not respond to calls / emails from 17th District Court sobriety court. Note, defendant expressed interest in the same sobriety court in July with no further contact at that time as well. So did you seek, well, right, because you were arraigned July 7th. So part of the problem that I'm having, counsel, is that it appears as though the attempt for sobriety court by your client has been ongoing for 6 months. 6 months. I run a treatment court in this court, mental health treatment court. I know that it does not take 6 months
Of course.
for somebody to complete screening, have eligibility determined or otherwise. So why is it taking 6 months?
Yes, Your Honor. Certainly I can speak on that. And I would just note for the record as well. So I, as retained counsel, was substituted in on or about December 15th. So in a large sense, I've been playing a little bit of catch up with respect to the history of this matter. I note that only to say, from what I've learned from both speaking with Mr. Dobson from the other courts and seeing some of the communications, namely that being some emails that Mr. Dobson had received after the original sentencing date, he had received a new email from Redford at the very end of November, where they, again, that was an email where they go through the various phases and such. Mr. Dobson did show me a call log where he did attempt to call them several times in December to be responsive as part of that process, which I understand is much later than July.
I understand, but let me just ask a follow-up
Sure.
to that. Why didn't you just respond via email, sir?
Why didn't
Why,
Yes,
she was
Mr.
asking why you didn't respond via to their email. Your Honor, if I may just very briefly interject before I allow Mr. Dobson to further respond to the question. One of the things that I've learned, and particularly at the end of December and early January, and I actually learned a great deal of this from Mr. Dobson's mother, who was able to be present on January 7th, because she does now live out of state. I've learned that Mr. Dobson has several very significant intellectual and learning challenges or disabilities. And I believe from speaking with Mr. Dobson and his family that those challenges or disabilities very significantly impacted his understanding, both in terms of document intake completion, understanding what his obligations or responsibilities were. Mr. Dobson has explained to me that over several instances or courses, primarily closer to July, when he did first express interest in this, he was under the impression that it was the appointed counsel at that time that was in coordination with the court. I understand that he should know that it is his responsibility, that he does need to be responsive and engaged. I would say that he's certainly, in that frame at this particular time. Unfortunately, though, from about July up until October, he operated on a faulty understanding, a faulty belief that it was the appointed counsel or his attorney was the individual to be in coordination for screening purposes. I've explained to him how that is a misunderstanding. I have explained to him how he does have to be, responsive, that, he has to go through the screening, that can't be done for him, things of that nature. So since I've engaged with Mr. Dobson and have worked extremely closely with him, I do believe that there has been a very significant, change and development in his own understanding of what these circumstances are, what sobriety court, means, entails, what his obligations and responsibilities are. And this is with absolutely, no disrespect to his former counsel. I think there was a night and day difference in terms of what he understood then versus what he understands now. And I've tried to work very closely with him, understanding those challenges or disabilities that are impacting his understanding, his reading, his completion of these documents. So I'm right there with you, Your Honor. I know that, sobriety court is a process that it does, entail to go through the screening, but it should not take 6 months. I only wish that I could have engaged with Mr. Dobson that much earlier to be, that much more involved with him to have ensured that this could be done, timely and successfully. But
So what are the, you indicated there are some intellectual disabilities for your client. What are those?
so, Your Honor, Mr. Dobson has been formally diagnosed with ADHD, obsessive compulsive disorder, with a I think, a more extreme or significant qualifier that they've attached to it. Now, I've worked really closely with his mom to try to understand the more technical or formal terminology, but he has been diagnosed as he and his family have described it as slow learner. He's been on lifelong IEPs throughout his entire schooling. I was trying to get copies of that, but unfortunately, I wasn't able to receive that. His family hasn't preserved from his high school and lower education, but they have noted to me, Mr. Dobson's been very forthcoming with me that as difficult as it is to talk about these challenges, because he's very proud of himself for being able to be successful in school and overcome them, but they are very significant. And so I wish I had a more formal term than slow learner, as his family has called it, but they have acknowledged to me that he was on IEPs from an extremely young age up and through the completion of high school.
And was that from the ADHD diagnosis or from a learning disability?
I think it's from learning disability, Your Honor. I think the ADHD is secondary, but that I did want to acknowledge that one because I do have the more formal terminology for that.
Okay, and sir, how are you doing in your classes regarding electrical engineering?
I graduated, Your Honor.
Okay, and so when did you graduate?
I believe terrible with months. I believe it was October.
October of 2025, Your Honor.
Okay, and so when you graduated, did you graduate with a diploma, a certificate,
A diploma.
Okay, and so what was your grade point average when you graduated?
It was a 3.5.
That's great for electrical engineering, because that makes my head hurt, right?
Your Honor, he's
So-
doing extremely well.
Yes, and that's
Just a
great.
job opportunity that unfortunately they had to rescind just due to the pending matters, but they did, the individual we spoke with did indicate that, at the right time in the future, if he's still interested, they will be happy to take him.
Okay, and that's good, sir. I ask those questions, counsel, because I also have children that have, one has ADHD, another one has learning disability. That's never once been utilized as an acceptable excuse to not follow directions or to not understand something. And I would beg to disagree that your client didn't understand some of what his responsibilities were. Perhaps he may not understand the criminal procedure, although I also find that hard to believe since this is not his first time, especially with this offense. And so I can understand your client has had some learning challenges and whatnot, has had IEPs, but I do not find that that's an excuse or an acceptable excuse to have prolonged the treatment court for 6 months.
Absolutely. And Your Honor, I only interject just to be very clear in this particular point. I'm not trying to provide this as an excuse or to otherwise explain Mr. Dobson's failures in that regard, but rather I simply provide it for context. Because, quite frankly, Your Honor, what I do think is significant and noteworthy is there are additional efforts I have not necessarily been able to provide on the record quite yet, but there are other efforts that Mr. Dobson has meaningfully self-initiated following December 15th and the substitution of counsel that I do think speak to the change of understanding, the change of both appreciation and engagement. To that point, Your Honor, Mr. Dobson has commenced both a course of AA participation. He has been attending AA on a regular basis since December 23rd, Your Honor. He also had engaged and reached out to counseling. Unfortunately, he wasn't able to complete a counseling session because after enrolling and engaging, they rescinded because they wouldn't accept his insurance, and he doesn't have sufficient out-of-pocket funds, so he can only go through insurance. So we were either through the court, if through sobriety court or otherwise seeking to find support in that sense, but he has engaged in several efforts that are self-initiated with the assistance of counsel. And so I have, fortunately seen a significant turnaround in short time. I understand that's a much shorter window of time compared to the period prior, but I do think that the efforts he is engaging in at this time are reflective of a renewed, deeper understanding and appreciation.
Okay, and I can appreciate that, counsel. So my question is this: has your client contacted his insurance company for a list of treatment providers that accept his insurance?
That's what I was currently about to do.
About to do. When did you begin your quest for treatment? And last week?
Last week,
Last week was the last update from them. I have worked with him much earlier on. I think part of the delay with going through his insurance to find other providers was in large part because when he first connected with this particular provider and they had indicated that they take his insurance and he had ceased looking elsewhere because he was operating on the response indicating that they were working with him, were scheduling with him, only to then be told that they weren't taking his insurance and that he needed to look elsewhere. His father has excellent insurance through Ford, right?
yeah.
Through Ford Motor Company. And so they were beginning to explore what options are available through that as well.
I also like to add, Your Honor, as so silly as it may sound, I did not think to call my insurance. My mother-in-law told me, hey, you should call your insurance. So that's why it took now. Someone had to bring it for me, and that's why I'm going to do it.
You're married?
No, I'm not married. It's just easier to call her that.
His girlfriend's mother's.
Oh.
He and his girlfriend do reside together now. It is truly like a partnership. Mr. Dobson is quite young, but what I found from speaking both with him and his partner is they are the quintessential older couple in a younger body. So they are not married, but very much my impression is they live very much like a married couple.
Okay. So let me do this. Well, at what stage counsel is, so let me, hear how I ask my questions because I'm not sure if we're going to, what's your plan for the bond violation?
So, Your Honor, I did want to advise the court that I was contacted, but just prior to MLK Day from the officer in charge out of Dearborn Heights that charge was just filed. I have filed my appearance with them. They did set an arraignment date, albeit the court set that arraignment date for February 27th. However, I've been in contact with the court. They've advised us that we are able to appear on any Friday for purposes of having Mr. Dobson arraigned in the 20th District Court. My request to the court for sentencing or for bond violation was if the court were to place Mr. Dobson on a period of probation so that the court maintains strict oversight and conditions over Mr. Dobson, we are in a position where we can have him arraigned perhaps this Friday as we were beginning to talk about. So I did want to advise the court that as it relates to that matter, we have engaged with that court. We are responsive to that court. We are planning to have Mr. Dobson arraigned. So I don't know if the court is either inclined to place Mr. Dobson on a period of probation or would otherwise prefer to provide one more brief adjournment for purposes of addressing that, following up on the Harperwood Sobriety Court or counseling for purposes of ensuring Mr. Dobson has adequate rehabilitative resources.
So I'm not opposed, counsel, to setting out the sentencing one more time to perhaps for you to reach a global resolution as far as both cases being referred to sobriety court. Here's a couple challenges though. One, your client lives in Redford. I don't know how easy it will be for him to get to Harper Woods. So that's something that needs to be looked at. There's also a sobriety court in Dearborn in the 19th District Court. I don't know if they have any openings or not. So I suggest those, since those are a bit more geographically convenient for your client. I was intending on conducting the bond violation today I don't know if you've spoken to your client regarding the bond violation and whether or not he's wanting to set this for a hearing, or if he's pleading guilty, what that looks like. I don't know what you've indicated.
Your Honor, I have had an opportunity to speak with Mr. Dobson. The nature of the violation, as he and I have discussed, I do not believe is necessarily appropriate for a hearing. Mr. Dobson is prepared to respond to the violation allegation. And very much, as the court indicated in the inclination, we are hopeful that the court would provide that opportunity for a global resolution.
Okay, so I'm going to arraign you on the bond violation. And obviously the bond violation is that you violated bond by, it's alleged consuming alcohol in Dearborn Heights, and then arrested for operating while intoxicated, third offense. And further, that you were at the same time also arrested for driving while license suspended. So those are the charges that are, sorry, Ellen, that are alleged for the bond violation. So I'm going to indicate a plea of not guilty. And counsel, it would behoove you and your client both if you can take your client, get your client into the 20th District Court sooner than later, because I'm only going to go out 4 weeks. That gives you time to handle the arraignment, the probable cause conference, speak to whoever you have to speak with at the Wayne County Prosecutor's Office, and communicate with the treatment courts that you're looking into.
Thank you, Your Honor. We appreciate the court's consideration.
Mr. Dobson, how'd you get here today?
Uber.
How much did that cost you?
I honestly, I didn't even look.
Well, pull out your phone. Pull up the app. Let's see what it says.
It was $30, Your Honor.
What are you typing in there, sir?
Oh, no, I was on Chase. I was looking at them charging me.
Oh, I wanted you, okay, I was having you pull up the Uber app.
Yeah. Yeah, use that.
Does February 25th work for you both?
Yes, Your Honor.
Does the afternoon work, counsel?
Yes, Your Honor.
Okay. 1:30 p.m.
Yes.
From the Uber app pulled up?
No, it's not pulling up.
And here's what the court's going to do as well. The court's going to amend, let me see. Amend your bond condition to include an alcohol tether. Actually, we're going to do a sober link, and you're going to test 6 times a day, sir.
Thank you, Your Honor.
I have some serious concerns for safety of the public. So I find that that will be one tool whereby testing every 4 hours will give this court some confidence that you're not consuming alcohol. No kratom, Nothing, no substance, sir, unless it's recommended by your treating physician.
Yes, Your Honor.
No kratom, no, anything that you can buy in the store that has, hallucinogenic changes, some, opioid-like, responses, nothing. Stop over at probation. Somebody will be with you shortly, to give you information regarding the SoberLink. Okay?
Thank you, Your Honor.
Thank you, Your Honor.
And just be aware, counsel, I am not inclined to adjourn, because there's not been a response by the Wayne County Prosecutor's Office, or there's not, been any outreach to the treatment courts. There's a multitude of different treatment courts you can reach out to. I've given you 5 weeks.
Your Honor. Quite frankly, I would not dare ask for another adjournment, even just looking at the record, understanding, the circumstances. We are very prepared to make sure that we are promptly able to resolve this.
All right, very good. Thank you. Have a good day.
Likewise.
Hey, thanks for watching this clip from TCF Live. If you enjoyed it, please leave a comment, like, and subscribe if you haven't already. And you can join us weekdays live, 9 a.m. Eastern, 6 a.m. Pacific, right here on this channel.